This is 230094 OD. This is Van Buren Township versus Patrick Dominic Hill. May I have your appearances, please?
Good morning, Your Honor.
Yes,
May I please escort Ezra Goldman on behalf of Mr. Hill. And Mr. Hill, you can say hello.
Yes, I'm here, Your Honor.
State your name for me, sir.
Patrick Hill.
Thank you, Mr. Hill. Today is the day and time set for sentencing in this matter. There was an offense date of January 18, 2023, at which time Mr. Hill was charged with operating with a blood alcohol content of 0.17 or more. Mr. Hill and Mr. Goldman appeared before this court on March 16, 2023, and entered a plea of guilty to the reduced count of operating while intoxicated. As is this court's policy, Mr. Hill was referred to the probation department for an interview and the development of a sentence recommendation. The court has received that recommendation, reviewed it in its entirety, along with the police report from the incident that occurred in Van Buren Township on that January 18th day. The court's also taken the opportunity to review Mr. Hill's driving record. The court is ready to proceed this morning. Mr. Goldman, are you ready to proceed?
Yes, Your Honor.
Have you had the opportunity to review the PSI with your client?
We've reviewed it, Your Honor. Yes, thank you.
Is that document factually accurate?
It is factually accurate. The only thing I would like to point out to the court is that there's an indication that there is no proof that Mr. Hill has been a smart recovery, and it's just self-reporting. He does have proof. That might be a communication slip-up, but he does have proof that he's been regularly attending that program, and he'd like to keep going to it if the court will allow that.
I'm sorry, there's proof that he's been participating in smart recovery?
Exactly, Your Honor.
He just has not provided that to the probation department.
Apparently, that's what we got.
Mr. Grant is on from the probation department. Any update regarding that small point, Mr. Grant?
No, I don't have anything as of yet. It was Mr. Hicks, though, that did this PSI, but I do not actually have any documentation as of yet.
We'll circle back to that in a moment, Mr. Goldman. Was there something else?
No, Your Honor. I have comments before the court issues its sentence, but I don't have anything else about the report.
Your comments?
So, Your Honor, I know that it might be an unusual adjective to use in this case, but I thought that Mr. Hill's presentation was refreshing, because I know the court, a lot of people that say, oh, I don't have a problem, it's a one time and there's really nothing wrong. And Mr. Hill came in and said, I've had a problem for years and I need to take care of it. And of course, as the court knows, that's the only way to take care of something, is for the person himself to realize that he has a problem. So Mr. Hill is very, very aware that he had been drinking too much. He has not had a drink since this incident. And I think he's on a good road. And I think 12 months of probation is perfectly fair under the circumstances. I don't have any problem with that. And I don't think he's going to give the court any trouble. And I question whether the 60 days of monitoring by device is necessary, but I leave that to the discretion.
Thank you. Mr. Goldman, here, and Mr. Hill, the issue for this court is that most of the sentencings are drinking and driving related. And so the first thing I do is always turn to the police report and look at the BAC, and I look at a 0.35. A gentleman that's on a road, on a highly traveled road at 6:35 in the evening, rolls his vehicle on his side and has to be extricated by the police. That's more than a short-term issue. You've indicated that Mr. Hill presented and advised that he has had a long-term issue. It is scary to me that he was on the road in that condition, and that just is the time he got caught. There's no way to guesstimate how many other days or nights he's been out there where he could have caused serious harm to himself or just someone from the public who happened to be traveling that way. And Mr. Hill, please know that's the extent of my lecture. It just scares me. It scares me that there's someone else out on the road who might have that same BAC or close to it. That being the case, that being the extent of the court's lecture, the court will adopt the recommendation that appears in the report prepared by Stephen Hicks, and will place Mr. Hill on 12 months of reporting probation with the associated oversight fees. Court will impose a fine of $500, cost of $100, their $75 crime victim fee, $125 of restitution to Van Buren Township, $50 mandatory state cost, and $20 fund fee. The oversight fee for probation is $40 per month. The court will also place Mr. Hill on 60 days of alcohol monitoring. Mr. Goldman, I heard your comments, but because of the BAC reported and the history of alcohol abuse, the court thinks that that length of monitoring is necessary and possibly beneficial. Mr. Hill will engage in outpatient treatment beginning within 30 days of today's date and follow all recommendations from that program and provide documentation to the probation department as directed and requested. If Mr. Hill has the documentation that he's already participating in an education program, he can provide that information to the probation department, and we will make the adjustments regarding that paragraph 7 requirement that he engage in outpatient treatment. Mr. Hill will not purchase, possess, consume any alcoholic beverages or controlled substances without the court's approval and will submit to random testing with a minimum of 2 times per month with ETG after he completes the alcohol monitoring. He will make regular monthly payments on the fines, costs, and oversight fees assessed in this matter. Mr. Hill, what will happen is that the probation department will be in contact with you because there is paperwork for you to complete to formally put the sentence in place. The goal, Mr. Hill, is for you to be successful on probation. The court wants to support you in not reoffending. If there's something you need, please reach out to the probation department proactively. Anything else, Mr. Goldman?
That's it, Your Honor. Thank you so much.
Anything else, Mr. Hill?
No, Your Honor.
Good luck to you, sir. Have a good afternoon.
Thank
Have a great
you.
day, Your Honor.
Good morning, Mr. Hadley.
Morning, Your Honor.
How are you today, sir?
I'm doing very well. Yourself?
I'm super. Are you?
I'm a little early. I'm the VOP counsel today. I just realized there weren't any set till 9:30.
Here's the question, and I think we've gone back and forth a little bit about this. We have Mr. Bowditch showing as being connected to Ms. Francis' case. Now, if you're just here for the violations, who's here available for someone who was MIDC and arraignment of plea?
I can handle that. I don't know that we've really. I think they just sort of put me on as your, I guess, like maybe like house counsel for today. So I'm happy to cover whatever. I just technically I'm only on the VOPs. So I know like Mr. Grant always sent me over like all the forms for that, but I don't have anything for any of the sentencings.
Josh, I actually did just send you.
Oh, you
a
did?
update this
You
morning.
know what, Judge? He did. I see that.
It was just in case.
So, Your Honor, I'm fine covering that. Ms. Francis would like to meet with me in a breakout room to review the pre-sentencing report.
Ms. Francis, you'll see an invitation to go into the breakout room with Mr. Hadley. Please go there with him.
Okay,
Thank you, ma'am.
thank you. Mr. Grant, do you have the next
probation date for courtroom 1. Do you have that handy?
Yeah, I want to say our next court date is the 22nd.
Thank you.
We are all set to proceed on Miss Carly Francis whenever the court is ready for us.
Thank you. This is 23HR 02944OD. This is Huron Township versus Carly Claire Francis. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Adley appearing on behalf of the defendant. Miss Carly Francis is appearing via Zoom. Miss Francis, please state your name for the court.
Carly Francis.
Thank you. Today is the day and time set for sentencing in this matter. Ms. Francis was charged on March 18, 2023 with operating while intoxicated in Huron Township. She appeared before this court on April 13, 2023 and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy in drinking and driving offenses, Ms. Francis was referred to the probation department for interview and the development of a sentence recommendation. The court has received that report, reviewed it in its entirety, along with Ms. Francis' criminal history, driving record, and the police report in this matter. Court is ready to proceed with sentencing. Mr. Hadley, what say you on behalf of Ms. Francis?
Your Honor, we have no corrections, deletions, additions to make the pre-sentencing investigation report. We find it accurate. We would ask the court to recommend or to adopt the recommended sentence of the 24 hours of community service, fines and costs with no probation. The only question that we did have, and maybe Mr. Grant might know, there was a specific dollar amount of 241 in restitution, it looked like, to Huron Township. We just weren't sure what that was for, and we're hoping maybe somebody knew. We're not contesting it, we just didn't know what it was.
Mr. Hadley, attached to the police report is the Huron Township cost summary. They list the officers, First Sergeant Cassim and Officers Wolf, Kakash, and I'm not gonna say the other name, it's LJALJEVIC. The officers involved, the hours spent on this matter, the breathalyzer data master test charge, the supplies and materials fees, police administrative expenses, and the court billing or administrative collection expenses.
So
That's
essentially,
the
it was
Huron's request for reimbursement.
so it was data master related fees, basically. It sounds like, I mean, that one's, I guess that's a little bit new and on me about the officer's time, but yeah, I understand what it is now. Ms. Francis, does the court's explanation of what the other $241 makes sense to you now?
Yes.
Okay, Your Honor, with that being said, we'd like to proceed with sentencing and ask again that the court adopt the recommended sentence from the probation department.
Thank you, Mr. Hadley. The court is going to adopt the recommendation made by Anthony Grant in his report. Mr. Grant indicates that this is Ms. Francis' first alcohol-related offense. He does not see the need to place her on probation. The court will impose a fine of $300, cost of $100, their $75 mandatory crime victims fee. The restitution is broken out into a $35 reimbursement for housing at the Huron County Jail, then $206 in restitution for the other officer hours, supplies and whatnot that the court previously enumerated. There's a $50 mandatory state cost and $20 fund fee. That total fines and costs are $786. The court will also impose 24 hours of community service that Ms. Francis is to complete with a nonprofit and to provide documentation to the probation department showing that she has completed that community service. Ms. Francis, if you're not already in a relationship with a nonprofit, you need a list of places where you can get your hours done. Please reach out to the probation department. They have folders and folders of agencies that you can do the hours in. The court would suggest to you that the sooner you do that, the better. Additionally, you'll need to be in contact and communication with the court's collection department to set a payment plan for this $786. If you are having trouble finding a place to do your hours, please again, reach out to the probation department. If you are having issues making your payments, again, reach out when it's a small problem. Don't let it become a big problem, okay?
Okay.
Ma'am, the purpose of sentencing is to keep you from reoffending. The court wants to be supportive of you and everything that you do going forward in this matter. Anything else, Mr. Hadley?
No, Your Honor, thank you very much.
Anything else, Ms. Francis?
No, ma'am.
Good luck to you, ma'am. Have a good week, okay?
Okay, thank you so much.
Thank you.
Mhm.
Your Honor, Mary Ann, I have a little unusual questions for tomorrow. I have a 9 o'clock pretrial. It's with a Holly Schmitz. I kind of got a little bit of a jumbled dance card tomorrow. If we logged in like right at 9 or maybe like 5 minutes till, do you think there's any chance we could be the first one up? Didn't look like it's too busy
Absolutely,
tomorrow.
Mr. Absolutely, Mr. Hadley. I just don't have the docket in front of me.
It's not too bad tomorrow. Looks like we got 2 at 9 and then 2 at 9:15. So I was just thinking, I'm like, yeah, hopefully I can.
The rule is I will call the case early if you get on it. You might need to remind me or Mary Ann in the chat. As long as the prosecutor's here, we'll go.
Okay. I just reached out to the prosecutor on this one. It's a little bit of a unusual case. Okie dokie.
Unusual case. See, Mary
Not
Ann, I don't like
unusual
those
case.
words.
I'm trying to get one of those kids talk interviews ordered up, and everybody's not really sure when law enforcement doesn't kind of take the initiative to get that forensic interview of a child witness done. I think the APA and I are both playing this. Okay, the law enforcement didn't do it. What do we need to do to get it done now?
Understood.
Blind leading the blind a little bit, I think. So we'll get through it. Actually, I'm looking at this week, Your Honor. What a week! I'm with you for at least a little bit of every morning this week until I leave for Atlanta. So busy dockets.
Leaving for Atlanta?
Indeed, going down to see Mom for Mama's Day.
Oh,
I usually try to go down there when it's. I don't know what the weather is down there yet, but I feel like I may have already missed that window of nice weather in Atlanta. It might already be hot.
well, yesterday's 80 degrees at 6 p.m. caught me off guard.
I think I'm kind of ready for it, but yeah, if we just a little bit, it sounds like so stereotypical, like Midwest now, but I'm like, I just want a little more spring before it gets hot. Just give us a little more like the windows open at nighttime. Your Honor, did you guys meet the new attorney who's been Matthew Wayne, one of the prosecutors? I think it's Belleville. Is that where Shane Nolan had usually been doing the cases before?
It was Mr. Nolan. No, I have not met this new prosecutor, a new prosecutor.
Or yeah, I think he's with the same firm. I don't know if he's replacing Shane, but he did the mock trial in Judge Oakley's courtroom last week with me. Really sharp, nice guy. I just didn't know if you guys had him in your court yet.
Oh, no, when he was in the building, no one brought him over or,
Did the
me.
introductions.
nope.
Yeah, he
I
was.
guess I'll
It
just
sounds
wait
like
until I'm on the Belleville.
I think he was with Wayne County for a while, did Inkster, did like some Hamtramck prosecution. So he's got some chops. He knows what's going on.
I look forward to having the opportunity to meet him.
Yeah, it'll be a nice addition. Mm.
Mr. Roberson?
Yeah.
Have you spoken to your attorney today?
No, I spoke to him on Friday.
And he told you to log on this morning?
Yes, ma'am.
Mr. Roberson, you might want to give him a call. This case was scheduled at 9 o'clock. I'm prepared to call the case.
Okay, I'll give him a call right now.
Thank you. Mary Ann?
Yes, ma'am.
Would you please get a pretrial date for Van Buren?
Sure,
Thank you.
you're welcome. June 1st at 9:50 with Judge Green.
Thank you, ma'am.
You're welcome.
Good morning, Ms. Rich.
Good morning.
We have not seen Mr. Mays as of yet.
Okay,
Have you, are you expecting him this morning?
I am, but I have not spoke to him.
Okay, To the gentleman that just joined us in the black bathrobe, your name, please?
Jeffrey Lee.
Thank you, Mr. Lee. Mr. Lee, we're going to get you into a breakout room to discuss the violation with Mr. Hadley, okay?
In Your
Okay,
Honor,
thank you, Your Honor.
Mr. Lee's actually already taken a proactive approach, reached out to me, and we did have a chance to speak this morning already. Mr. Lee, is there anything additional that you need to discuss with me before we have the case called?
No.
Okay, Your Honor, we're ready to go on Mr. Lee whenever the court's ready for us.
This is 190210FY. This is State of Michigan versus Jeffrey Lee. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of probationer Mr. Jeffrey Lee, who's appearing via Zoom. Mr. Lee, please state your name for the judge.
Jeffrey Allen Lee.
Thank you. Mr. Lee, are you in fact wearing a bathrobe?
Yes.
You understand that this is court that's being streamed live on YouTube.
No, I didn't know it was on YouTube, Your Honor.
Would you present to court in a bathrobe, sir?
No, Your Honor.
Okay. Today is the day and time set for a show cause in this matter. There's been a violation, alleged violation noted in this case. Anthony Grant from this court's probation department has sent the violation information to the courtroom indicating that Mr. Lee failed to report on April 12, 2023, failed to enroll in substance abuse treatment as ordered by the court, failed to enroll in drug and alcohol testing, failed to provide documentation of mental health treatment. Additionally, he has failed to pay on the fines and costs assessed by this court and now owes the court $1,235. Mr. Hadley.
Your Honor, as to the allegations, I've had a chance to speak with Mr. Lee. He understands his right to have a contested hearing. He admits responsibility to these violations and would ask an opportunity to give the court an explanation as to kind of what's been going on that's caused this and what he intends to do to rectify it.
The court accepts the defendant's admission of responsibility. The explanation, Mr. Hadley.
Your Honor, I'm going to let Mr. Lee kind of address the court directly himself, but what I can state is I know that, again, as I mentioned, he's reached out to me as soon as he received the show cause, kind of explained to me what I'll best describe as an unfortunate, kind of tragic set of circumstances with some death in the family. He also had begun recently, I believe, change of residence quite suddenly as well. Mr. Lee, I don't want to misstate what has kind of happened, but very briefly, can you explain to the court what's kind of been going on over the past couple of months in your life?
Recently, my grandfather was diagnosed with lung cancer, so we had to watch him basically to his demise, and just restructure our lives around my grandmother, and not to mention me moving, and it's just been a lot going on with my life, and I'm finally situated in a new place, and not over grieving, but I'm getting past grieving.
And most importantly, Your Honor, today, Mr. Lee did indicate to me that financially, he's now moving into a spot where he's going to be able to start following through with the obligations that he has. We would ask the court to give Mr. Lee this opportunity through probation to continue and demonstrate through his behavior that he's serious about complying.
Thank you. Mr. Grant, is there anything you'd like to say?
The only thing that I have to say is Mr. Lee may have reached out to Mr. Hadley, but I have attempted to contact him through email, through phone, at least 6 to 7 times, never successfully talking to Mr. Lee about his probation. So everything that he's stating today is news to me because he refuses to answer or call me back.
Mr. Hadley, you've been on this court's docket for sentencing before, and you are aware that this court typically concludes by saying to a defendant that the purpose of the fines and costs, treatment order, all that other is to keep somebody from reoffending, and that this court wants to be successful, wants the defendant to be successful. This court wants to be supportive in everything that has been ordered, which means if you need something, reach out to the probation department. Reach out when there's a small problem, when there's a hiccup in life, to explain why you are not doing what you've been ordered to do as a consequence of your actions. And when this court calls these proceedings and Mr. Lee shows complete lack of respect for the court, for this courtroom, for the attorneys, for the probation department who have logged on by not even bothering to put on a shirt, it suggests to the court that he is not taking this matter seriously. This offense date was from July 1st of 2018. This is an old case that should have already been done over and closed. And although the court accepts Mr. Lee's plea of responsible to the violations, the court does not hear or plan to move forward. I hear that he is resituated and is able to resume those things that were ordered back on March 6, 2023, when Mr. Grant indicates to the court that he has made multiple efforts to reach out to Mr. Lee, and Mr. Lee has failed to respond. That's the opposite of what the court would have said to Mr. Lee at the time of sentencing. What the court would have said is Mr. Lee is to reach out to probation if he needs something, not the other way around. Thank you, sir. That being the case, although the court accepts the plea of responsible, the court is listening for how Mr. Lee intends to move forward, and both resuming, or not even resuming, starting payments, enrolling in treatment, starting to be compliant with testing.
Your Honor, may I say
You don't need to
one more thing?
Absolutely.
When I first came in encounter with the probation, I had already went through like what I assumed would be acceptable treatment, and it wasn't accepted. So I had to go back and I had to find new treatment and new things. So that was a restart. I also lost my cell phone in the midst of everything that was going on. So I didn't have a cell phone for over a month. I'm not making any excuses. So that's why I didn't bring it up. I'm just ready to get on what I'm supposed to do, Your Honor. And I promise that it's going to be up from here. And I can't repeat the past.
Thank you. Mr. Lee, I appreciate that. And the small lecture I just gave you is because it troubles me when someone does not respond to Mr. Grant. And I hear you say that you didn't have a phone, but this court building has been in the same place now for over 2 years. Our old court was right next door, so being unable to find us or send a letter or anything to get back on track, it's just not acceptable. The court has accepted the plea. The court will direct you to correct these oversights, resume payments, enroll in treatment, enroll in the drug and alcohol testing. The court will actually schedule you to return for review on June 5th, 2023 at 9 a.m. back by Zoom. And if you have not received a phone number and email to be in communication with the court's probation department, if Mr. Hadley has not given that to you, Mr. Grant will put it in the chat. If Mr. Grant is satisfied with the progress you make between now and that June 5th review date, Mr. Grant is able to send a message up to the courtroom, and we will remove that hearing from the court's document. That means that you have enrolled in treatment, started testing, and started payments.
Yes, Your Honor.
Understood, Mr. Lee?
Yes, Your Honor.
Anything else, Mr. Hadley?
No, Your Honor. Thank you very much for giving us this opportunity. And I think Mr. Lee understands and needs to make the most out of this between now and June 5th. We thank the court for their time. Thank you, Mr. Grant.
Thank you. Mr. Lee, good day to you, sir. And best of luck for your family and the recent developments with your grandfather, okay?
Thank you, Your Honor.
Have a good day, sir. Ms. Rapp and Mr. Grant, this court is also scheduled for arraignments today. We've received indication that there are 2 pending from Romulus. When Mr. Bowditch hops on with Romulus, we will take a break in these proceedings. But in the meantime, we'll continue to push through. Mr. Mays, are you ready with Ms. Rich?
I am, Your Honor.
This is 230004 FY. This is State of Michigan versus Amber Marie Rich. May I have your appearance, please, sir?
Good morning, Your Honor. William Mays on behalf of Ms. Rich. Amber, state your full name for the record, please.
Amber Marie Rich.
And Judge, I reached out to the probation office this morning indicating I hadn't received a PSI. She did meet with probation on March 20th. Apparently, I was told in that email that there was no intention of doing a PSI, that it was just to see if she's 74, to confirm 7411 eligibility, which was confirmed. So, understanding all that, I think that we're ready to proceed with sentencing. I would ask that the court simply impose fines and costs and place her on the 7411 deferral status, and any reasonable conditions that you might want to add to it, Your Honor. I know that you should know, Judge, that Ms. Rich has struggled in the past. She is but does not have any sort of a record in these regards. But I know that she fought this case. It went from Van Buren to the state, and finally we were able to get it resolved. So if you have any questions regarding the offense, I'm more than happy to answer those. But otherwise, I would just ask for fines, costs, community service, and 7411 deferral status.
Thank you. Mr. Mays, you mentioned that she struggled. Has Ms. Rich engaged in any kind of treatment?
Ms. Rich, I know that she has, but what is it, Ms. Rich?
I have in the past been to like NA meetings. I have excuse me, I've been to AA meetings. I have been to an outpatient facility in 2016 for mental health. I believe that's it.
Thank you.
Oh,
There
I'm
was an
sorry.
offense state in this case of, I'm sorry, go ahead, Ms. Rich.
I am currently seeing a psychiatrist too, monthly, and a therapist.
Thank you. There was an offense date in this case of August 19, 2021 in Van Buren Township, which time Ms. Rich was charged with possession of methamphetamine or ecstasy, appeared before this court on March 22nd, 2023, and entered a plea to the reduced charge of use of a controlled substance, and the court dismissed a second count of operating while intoxicated. And at the time that the plea was taken, there was not a criminal history in the file, so the court referred the matter to probation to confirm the eligibility. And as Mr. Mays just indicated on the record, that eligibility has been confirmed. When the parties appeared, the prosecutor did not ask for any treatment, asked only that the plea be taken pursuant to 7411. The court did previously authorize that. And Ms. Rich, the court will impose the following, will place you on 6 months of reporting probation. Will order 24 hours of community service to be completed during that 6 months time. Ma'am, if you don't already have a relationship with a nonprofit to do those community service hours, reach out to the court's probation department. They will assist you in getting connected with an agency where you can do those hours. The court will also impose a fine of $300, cost of $200. There is standard $75 crime victims fee, $50 mandatory state costs, and $20 fund fee. Ma'am, you can be in contact with the court's collection department or the probation department to establish a payment plan in this matter. Probation department will be in contact with you to have you execute documents to formally put your sentence in place. Understood?
Yes.
Anything else in this matter, Mr. Mays?
No, thank you very much, Your Honor.
Thank you. Ms. Rich, good luck to you, ma'am.
Thank you.
Have a good day.
Thanks, you too.
Thank you. This is 1930160D. This is Van Buren Township versus Antonio Roberson. May I have your appearance, please?
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of defendant Antonio Roberson.
State your name for me, sir.
Antonio Roberson.
Thank you. Mr. Burgess, this court received on Friday, May 5th, 2023, your motion to set aside the plea that was previously entered, and note that it was sent to Madam Prosecutor for the township, Angela Manarino. She has not appeared this morning, and I was not sure if you had had any response or communication with her regarding your motion.
Well, Judge, I did speak with Ms. Manarino prior to filing it, and I did indicate in my motion, consistent with her emails to me, that she does not oppose my motion. I do have emails reflecting that she did not object to asking that we do it. I'm sure the court understands what the reason for it and why we're trying to do it.
The court understands the reason, and although your motion indicates that she did not object, there was no communication from her. But in as much as you've appeared this morning and indicate as an officer of the court that she has no objection, the court will grant the motion to set aside the plea. We'll note that the completed PSI and sentence recommendation is in the file and will continue to travel with the file. As requested in your motion, this matter will be scheduled for pretrial. That pretrial will be on June the 1st, 2023 at 9:50 a.m. And it will be in courtroom number 3 with Judge Green. It will be by Zoom. Court staff will mail notice of that June 1st, 9:50 a.m. date to your client at the address we have for him on Edmond Street in the city of Romulus.
Thank you, Your Honor.
Anything else, Mr. Burgess?
No, Judge. Thank you very much, Your Honor.
Thank you. Mr. Roberson, good luck to you, sir. Have a good day. You're free to go. Mr. Hadley, have you spoken to Mr. Whaley?
I have not yet, Your Honor.
Or Ms. Sutton? If you would want to go into the breakout with them, please go there. In the meantime, the court will call Mr. Wysocki's matter.
Absolutely, Your Honor.
Thank you, sir. This is 23SU001428OD. This is Sumter Township versus John Andrew Wysocki. May I have your appearances, please?
And good morning, Your Honor. For the record, Brian Stacy P 33014 on behalf of Mr. Wysocki. Please state your name.
John Andrew Wysocki.
And Judge, today's date
Thank
time
you.
set for the sentencing. I wanted to assure the court that I've gone over the pre-sentence report and recommendation with Mr. Wysocki. All the representations therein are accurate. Judge, my client is 65. He has 6 children, ages 30 to 9. He's been on disability for the last 2 years. He was a valued employee for 18 consecutive years with CVS, but he's not able to do that anymore. And he's having knee surgery on June 1st. So the age is catching up with him in that regard. And I know that he's taken this matter very seriously. And I believe he has something he'd like to say to the court this morning.
Yes, this is a terrible mistake that I made, and I guarantee it won't ever happen again.
He's had no previous contact with the criminal justice system, Judge.
Thank you, Mr. Stacy. Mr. Wysocki, I appreciate that position. There was an offense date in this case of February 3rd, 2023 in Sumter Township, at which time Mr. Wysocki was charged with operating while intoxicated. He appeared before this court on April 13, 2023 with his attorney and entered a plea of guilty to the reduced count of operating while visibly impaired. As is this court's policy, the matter was referred to the probation department for interview with the development of a sentence recommendation. The court has received that recommendation from Agent Anthony Grant, reviewed it in its entirety along with the police report. and Mr. Wysocki's criminal history and driving record. The court will adopt the recommendation made by Mr. Grant. Mr. Grant's report indicates that this is Mr. Wysocki's first alcohol-related offense. And the probation department does not see a need to place him on supervision. The court will impose a fine of $300, cost of $100. There's $75 mandatory crime victims fee. There's $50 mandatory state costs, $20 fund fee. There's $125 in restitution due to Sumter Township. That's $670. The court will also order 24 hours of community service at a nonprofit to be completed within 120 days. Mr. Stacy, the court heard you indicate that Mr. Wysocki is scheduled to have knee surgery the beginning of June. But there are community service opportunities available that should be able to fit with any limitations that he might have if Mr. Wysocki is not able to make a dent in that community service before that scheduled surgery. Mr. Wysocki, what the court needs you to do is contact the court to set a payment plan for the $670 that will be due and owing in this matter. And if Mr. Stacy, Mr. Wysocki needs additional time to complete the community service because of his recovery, please reach out to the probation department. Anything else in this matter, Mr. Stacy?
Only, Judge, as far as the community service goes, is there a list that that the court has?
Absolutely. There's multiple opportunities. So if you would have your client be in contact with the court's probation department, they'll get him connected to an agency that can fit his situation.
Great.
Thank you.
Thank you, Judge.
Have a good day. Good luck to you, Mr. Wysocki.
Thank you. You too.
You have a good day, Judge.
Thank you, sir. Ms. Seguru?
Yes, Your Honor. Hello.
Good morning, ma'am. What are you here for?
Good morning. I am actually here on Amanda Barton. It was under Kim Michon from NDS, and I am retaking over the case.
Have you been in touch with Ms. Barton regarding this morning's proceeding?
I have not, Your Honor, and I was actually calling in to inform the court that when she first received her papers, she was still in the jail in Monroe County. So she didn't receive the paperwork. And then I have tried contacting her since I returned, and I unfortunately cannot get in contact.
Hold on for 1 second.
Yeah, go ahead.
This is 200116 FY State of Michigan versus Amanda Lynn Barton. I'm sorry, Ms. Segura, you were starting to say that your client was in custody when the notice was sent?
Yes, Your Honor. And just putting on the record, Alyssa Segura with the Neighborhood Defender Service on behalf of Ms. Barton, P86432. Yes, I originally spoke with Kim Michon, who was assigned to this case. She stated that when Ms. Barton received the paperwork, or when it was sent to Ms. Barton at her address, she was still in the Monroe County Jail. So unfortunately, she did not receive that paperwork. She has since been released, and she did contact me. However, I was still on maternity leave at that time. I just returned last week. I have tried contacting her several times, sent calls and text messages. Unfortunately, her voicemail is not set up at this time. However, I did give her the information, but have not heard back yet.
What I would suggest is this court's policy is 15 minutes after the scheduled time. Ms. Barton's case was scheduled at 9:30. It's now 9:48. She has not appeared. So maybe with this being released and the notice didn't catch up with her, and although you've been in communication with her, she might not have a way to join us. The court is happy to put this matter over to allow you time to reach out to her additionally and get her on and maybe get her compliant. There is, I'm looking at either May 22nd or June 5th. Do you have a preference?
I do not, Your Honor. Any day that works for the court works for me.
We will adjourn today's show cause to May 22nd, 2023 at 10 a.m. That's back here with me, back on Zoom.
Okay.
Anything else, ma'am?
Nothing further from me, Your Honor.
Thank you. Thank you for joining us and giving us an update. You have a wonderful day, okay?
Thank you. You as well. Bye.
Thank you. Mr. Hadley, I received the update from Andy regarding the arraignments, and I thought I saw the jail come on at some point. Oops, I got Ms. Barton's file separated.
I did as well,
You
Your
talked
Honor,
to
and I
Ms.
received the bond recommendation. I just don't see where they went. Does anybody else? Oh, you know what? I see Lieutenant Harris in room 3 with Andy right now.
Have
Maybe.
you already spoken to Ms. Sutton or Mr.
I have.
Whaley?
We're prepared to proceed on Miss Sutton. I've attempted to move Mr. Whaley into a couple of different breakout rooms and have gotten no response yet. So Mr. Whaley, if you can hear us, I'm going to send you another request to join a breakout room. Please accept that, sir.
In the interim, this is 220054FY, State of Michigan versus Stephanie Renee Sutton. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley, appearing on behalf of probationer, Miss Stephanie Sutton. Miss Sutton, please state your name for the court.
My name is Stephanie Sutton.
Thank you. Today is a day and time set for hearing on the violation information received from probation department. Mr. Grant from this court's probation department has sent the court a memo indicating that Ms. Sutton violated the terms of her probation from the 14B district court by missing substance abuse treatment. Part of the sentencing for this case was that Ms. Sutton remained compliant with the probation she was already under from the 14B district court. The court did not want to duplicate the efforts that were already underway in 14B. The court received information that Ms. Sutton failed to appear for her substance abuse classes and was ordered to serve 10 days in the Washtenaw County Jail. Ms. Sutton appears to now be back on track and compliant with the 14B district court probation. The other issue that although she is now compliant in 14B, she has failed to make payments in the case in this court and owes $1,590 in this matter. Mr. Hadley, what say you on behalf of Ms. Sutton?
Thank you, Your Honor. On behalf of Ms. Sutton, as indicated, the technical probation violation, we will plead responsible to. We do come bearing good news, however, Your Honor, about the issue with the non-payment in this court when the court's ready to hear us.
Court's ready, Mr. Hadley.
Very good. Well, Ms. Sutton shared with us that she's recently obtained new employment with company Populous Cleaning, doing commercial cleaning. Great job. She will be getting her first paycheck on May 12th. Has indicated she's got various financial obligations, but she shared with Mr. Grant, I believe is my understanding, that as soon as this paycheck comes in, she's going to get on course with 34th District and start making payments as well. Regarding the programming, as you mentioned, she is back on course with her other probation. She's enrolled in Home of New Vision programming. It's going well. We would ask the court to consider all this when determining what the appropriate measures is in this case. And would also add, I guess, that I believe that as context for Your Honor, what happened in 18B, Ms. Sutton brought a note that she believed was going to excuse her absence from the day in question. Said note was rejected, and she did do 10 days in jail. So I guess I would state that the message about compliance has been received very loud and clearly already.
Thank you. Mr. Grant, any comment?
No, Your Honor, I did have the same conversation with Ms. Sutton, and it does appear she's back on track with 14B. And she did mention getting a new job and starting payments as soon as she got that first check. I'm content with her just getting back on probation, and I'll monitor.
Ms. Sutton, the court accepts your plea of guilty to, responsible to the technical violations of the probation previously ordered by this court, and will adopt Mr. Grant's recommendation that you be allowed to continue with the understanding that you will receive a check on May 12th, 2023, and that you will resume payments or start payments in this matter. Ms. Sutton, just for the record, you have another matter in this court from 2019 where you owe $460. You have not made a payment in that matter since November 4. You've been late on payments since November 14, 2022. So when you resume payments in this matter, you can make a payment arrangement in the 2019 matter, and they will roll the payment plan they will roll the payments into a singular payment plan, okay?
Okay, thank you, Your Honor.
Anything else this morning, Ms. Sutton?
No, ma'am. I just want to thank you for allowing me to get back on track and continue my probation. And as I said, as soon as I get my check, I will be down there to get back on track with my payments.
Thank you, Ms. Sutton. Good luck to you on the new job. You have a wonderful day.
Thank you. You too.
Thank you. Mr. Hadley, it looks like Mr. Whaley has moved. Go ahead. I'll see you when you're ready.
Mr. Whaley, I believe, is now into room 2. I'm going to meet with him and I'll be right back, Your Honor.
Thank you.
We're having a little bit of audio with Mr. Whaley, but I think we should be okay. A little audio issue, I mean.
Well, he has not brought himself back out into this main session. Romulus, who do we have up first, please?
Alexandra, Miss Manbright.
Thank you. These are, well, this is 210610 FY. This is State of Michigan versus Alexandra Manbright. May I have your appearance, please?
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Ms. Manbright. Your Honor, could I have the case number once again? I apologize.
210610 FY. Ma'am, state your name for me, please.
Alexandra Manbright.
Thank you. Today is the day and time set for the arraignment in this matter. Mr. Bowditch, how are we proceeding?
Your Honor, we would stand mute and waive the formal reading. I've also had a chance to discuss this matter with the officer in charge. They have no objection to a personal bond. So that's what we would be requesting.
Thank you. Before we get there, Ms. Manbright, you have an absolute right to be represented by an attorney in this felony matter. Attached to the front of your file is a petition for a court-appointed attorney. The court has signed that. You will be assigned an attorney going forward. It will not be Mr. Bowditch. It will be someone else who uses the information that you've provided this morning to be in contact and communication with you. You also have a right to be considered for pretrial release. This court has a bond recommendation form from Romulus Police Department requesting bond in the amount of $50,000, 10% because of outstanding warrants, with a request that you have no contact with the victim, in this case, Marshawn Hunt. Mr. Bowditch has indicated that the police department has removed the 10% request and is now asking for personal bond. Lieutenant Harris, is that the position of the department?
Your Honor, it is. Miss Manbright has been here for 2 days. She does not have contact with the complainant. They do have a child in common. However, he is an absent father. This is a case that she says is new to her. She's unaware of these circumstances. She's been nothing but cooperative while in custody, and we have no issue or no worry for her to the public or anyone else.
Thank you. Based on that modification placed on the record by the police department, the court will set your bond, ma'am, at $10,000 personal. That means you do not have to post any money, but what you must do is continue to appear and participate in these proceedings until this matter is resolved in its entirety. And as much as you have indicated that you have no reason to have any contact or communication with Marshawn Malik Hunt, the court will make that a condition of your bond. You will have no contact with the complainant in this case. Ma'am, no contact means no contact, no direct contact, no contact through third parties, no contact through social media. Although it's been placed on the record that you have a child in common, it's also been placed on the record that he is an absent father, which means there is no reason for you to have contact or communication. If this court receives information, allegations that you have made contact with the victim in this case, it could be viewed as a violation of the terms of your pretrial release. Those allegations could cause your bond to be revoked and you can spend the rest of these proceedings in custody. Understood?
Yes.
Ma'am, your next appearance date in this felony matter will be on Wednesday, May the 17th, 2023 at 9 a.m. in person in courtroom number 2 with Chief Judge Brian Oakley. Again, this case number is 210610 FY. Next appearance date, Wednesday, May the 17th at 9 a.m. in courtroom number 2 with Chief Judge Brian Oakley. Mr. Bowditch, Ms. Manbright has another matter. It's 21RP005080M, City of Romulus versus Manbright. Did you have the opportunity to discuss this case with her?
No, Your Honor.
Ms. Manbright, there is an allegation that you on February 12, 2021 committed the act of assault and battery. The warrant, there was previously a warrant in place for you for failing to appear in this matter. That warrant has been recalled. The court will have you stand mute to the charges against you.
Thank you, Your Honor.
Bond in this matter will be set at 5,000 personal. Again, ma'am, you do not need to post any money, but what you must do is continue to appear as directed by this court until the matter is resolved in its entirety. There was an indication in this file that the complainant was Sharon Hill. Ma'am, do you have any reason to be in contact or communication with that person?
No.
Do you know who that person is?
I don't.
Again, ma'am, no contact means no contact, no direct contact, no contact through third persons, no contact through social media. Andy, the name of complainant as Sharon Hill appears on a plea form in the file. If that is not the correct name for the complainant, let's make sure we have the correct name as part of the bond condition. Ma'am, your next appearance date in this matter will be on June 1st. My apologies, June 1st at 8:30 a.m. with Judge Oakley. Again, this is 21 RP 00508OM. Next appearance date, June 1st, 2023, 8:30 a.m. in person, live in courtroom number 2 with Chief Judge Brian Oakley. Ma'am, there will be court-appointed attorneys available to you for that misdemeanor matter on that June 1st date. Anything else in these matters, Mr. Bowditch?
Nothing, Your Honor.
Thank you. Ms. Manbright, good luck to you. Have a good day.
Lizzo, thank you.
Thank you. This is 230282FT. This is State of Michigan versus Kenneth Martez Wilson. May I have your appearance, please?
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Mr. Wilson. Your Honor, today is the date and time set for arraignment. We'd waive formal reading and stand mute. Ask the court to enter a not guilty plea on his behalf.
Sir, state your name for the record, please.
Kenneth Wilson, Your Honor.
Mr. Wilson, you've had the opportunity to speak to Mr. Bowditch, and you understand why you're here this morning, sir?
Yes, Your Honor.
Mr. Bowditch has indicated that you're waiving the formal reading of the charges and stand mute to those charges. Sir, you have an absolute right to be represented by an attorney in this felony matter. If you're unable to retain an attorney through your own resources or that of friends and family, the court is able to appoint one to you. There is a petition for court-appointed attorney attached to the front of your file. The court has signed that, and you will be assigned an attorney going forward. It will not be Mr. Bowditch. It will be another attorney that will use the information that you've provided thus far in this matter to be in contact and communication with you. Sir, you also have the right to be considered for pretrial release. The bond recommendation from Romulus Police Department indicates that they do not oppose a personal bond. Mr. Bowditch, any comment as to bond in this matter?
No, Your Honor, we have no objection to a personal bond. Mr. Wilson is a 31-year-old individual. I know what he's charged with seems egregious, but there was an explanation. I believe everyone understood it, and he's been good to the officers and kind, and he won't be a flight risk, Your Honor.
Thank you. Mr. Wilson, your bond will be set at 5,000 personal. You do not need to post any money, but what you must do is continue to appear as directed by this court until this matter is resolved in its entirety. Sir, your next appearance date will be on Wednesday, May the 17th, 2023, in person in courtroom number 2 at 9 a.m. with Chief Judge Brian Oakley. Again, this case number is 230282FT. Next appearance date, May 17, 2023 at 9 a.m. courtroom number 2 at the 34th District Court. Anything else in this matter, Mr. Bowditch?
Nothing, Your Honor.
Thanks, Your Honor.
Thank you. Mr. Wilson, good luck to you, sir. Have a good day.
Thanks, Your Honor.
Anything else,
Thank you,
Romulus?
officer.
No, Your Honor. Thank you, guys. Take care.
Thank you. Good to see you.
You too.
This is 22HR08299AOD. This is Huron Township versus Lamar Whaley. May I have your appearances, please?
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the probationer defendant, Mr. Lamar Whaley. Mr. Whaley, please take yourself off mute and state your name for the court.
Lamar Whaley.
Thank you. Today is the day and time set for a hearing on the violation information received from Shannon Rapp of the Probation Department Ms. Rapp, in her submission to the court, indicates that the case was adjourned for 60 days for Mr. Whaley to provide documentation of his substance abuse treatment and to obtain an alcohol monitor for 60 days. Mr. Whaley did obtain that monitor on April 28, 2023, and on that date, the service center, he had 3 test violations that show at 3:19 PM, a BAC of 0.013, at 3:22, a BAC of 0.010, and at 3:25 PM, a BAC of 0.007. Mr. Whaley has failed to maintain his payment plan. He's never made a payment in this matter and owes the court $1,266. Mr. Whaley has enrolled in outpatient treatment, which started on February 22nd, 2023, and continues through Sobriety House. His last alcohol and drug screen on April 14, 2023 was negative. Mr. Hatley, what say you to these violation allegations?
Your Honor, I think we bifurcate these and we would plead responsible as to the failure of payment, and ask for an opportunity to make a brief explanation and, more importantly, a plan to get right on that. As to the, I believe this is a SCRAM monitoring device. Is that what he was equipped with?
PBT device.
It was a PBT that these, so I guess that's what I was trying to figure out. It says, looking at the timing, Your Honor, from 3:19, 3:22 to 3:25, for the trace amounts to go from a 0.013 to a 0.011 down to a 0.007. After defending these cases and SCRAM violations, again, I'm not sure. Again, Ms. Rapp, we saying this was a handheld PBT that he did 3 of?
Correct.
All right. It was my understanding that this was a different monitor. I misunderstood. Mr. Whaley, knowing what the court is saying, which is he took a handheld breathalyzer that date, your position still is that you had not drank or consumed any alcohol, though, prior to coming in that day?
None whatsoever.
Your Honor, again, I think we would still stand by that and leave we understand the lower burden of proof of a preponderance, but for something to go from a 0.013 down to almost zeros in that short of a period of time, I would argue that's consistent with some other trace amount of use and would not follow the normal bell curve of alcohol consumption as it relates to a BAC.
Ms. Rapp, any comment?
I did speak with Smart Start about these 3 positive breath samples, and they did indicate that it does appear to be consistent with consumed alcohol.
That being the case, Mr. Hadley, anything else?
No, Your Honor, we would still stand by our position, which is, again, no alcohol had been consumed prior to him showing up to be equipped with an alcohol device. I would just ask the court again to kind of, again, maybe use the reasonableness of, does that make sense that this individual would have, again, knowingly gone in and drank beforehand? I would argue, again, much more consistent with something like a hand sanitizer, mouthwash. But again, we understand the people's position, and we will enter a plea of not responsible to the alcohol and a plea of responsible to the non-payment.
Thank you. Ms. Rapp, any recommendation on how to proceed in this matter?
Your Honor, I would like to recommend to add an additional 7 days on the alcohol monitor in lieu of those positives.
Thank you. Mr. Hadley, there was some comment you wanted to make regarding the payments in this matter.
Yes, it's just the Mr. Whaley at the time that payment was initiated in this was going through a landlord-tenant proceeding and was in the process of obtaining a new residence. He has done so. He's made security deposits, down payments, everything taken care of. So his statement to me and his statement to the court today is he does intend to start making payments promptly here moving forward.
Thank you. Mr. Whaley, are you able to start making payments in this matter within the next 14 days?
Yes, ma'am.
Thank you. The court has had the opportunity to hear from Mr. Hadley and Ms. Rapp, and will do the following. Will order that Mr. Whaley contact the court's collection department, establish a payment plan, and make the first payment within 14 days. The court will also extend Mr. Whaley's time on the alcohol monitor by 7 days. All other terms of your probation will continue, Mr. Whaley. And if something else comes up where you need the assistance or the support of the probation department, please reach out. If this court receives another indication that there has been a positive test result from your alcohol monitor, it will not be acceptable to hear the argument that the numbers don't make sense and aren't reasonable. Understood?
Yes, ma'am.
Only you know what happens on April 28th, but we'll consider this a clean slate. We'll add the 7 days. You'll resume your payments and hopefully be successful with the balance of your term of probation. Anything else in this matter, Ms. Rapp?
No, Your Honor.
Anything else, Mr. Hadley?
No, Your Honor. Thank you, everyone, Ms. Rapp, the court for taking time to hear us out today. Good luck, Mr. Whaley.
Mr. Whaley,
Thank
have a
you.
good day, sir.
Okay, you too. Thank you.
That concludes this court's probation docket for the morning. Andy, is there anything else in process right now?
Nothing at this time.
Thank you. This court will stand in recess. Ms. Rapp, Mr. Grant, Mr. Hadley, thank you for your assistance this morning.
Thank you, Judge.
Good to see everybody. Have a good day.
Hey, Josh.
I think Jeff sounds like he was tagged back in for arraignments, but I'm at my desk this morning. If you guys need me, just call.
Thanks.
Mr. Bowditch did both the ones we had, but thank you, Mr. Hadley.
Okay, excellent. See everyone tomorrow.